Could a landlord and tenant, by their written lease or rental agreement, agree to terms of entry into a unit that are greater or more restrictive than allowed under state law? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I got this comment here responding to our video about entry. I believe the video was about, does a landlord have to have a tenant's consent to enter a rental unit in California? And generally speaking, under Civil Code Section 1954, and unless the tenants, no, excuse me, I lost my train of thought here. A landlord can enter for about like 3 different reasons. All right, generally speaking, okay. Landlord can enter with the tenant's consent. Obviously, they had a mutual agreement to do so. The other way a landlord could enter without a tenant's actual consent is to give a written notice of entry pursuant to Civil Code Section 1954, and generally they have to give a minimum of at least 24 hours notice. Okay, that's presumed to be reasonable. Okay, now in this case, the commenter's comment noted that in the actual written agreement itself, that the parties agreed that both landlord and tenant would be present for all, entries. Okay, could you have a term with that? I would believe that is more restrictive than state law, so I think a court would enforce that agreement. Okay, I would probably, as landlords counsel, caution landlords for having very restrictive provisions about entry in the lease agreement. Under the law, a landlord is allowed to enter a tenant's unit if there's an emergency. They don't need consent or notice for that. I would hope in this lease that that's kind of outlined, that the landlord could enter pursuant to 1954. There might be a provision in the lease agreement that states that instead of 24 hours notice being presumed reasonable, 48 hours. Okay, like extra time. I think a court would enforce that. A common thing that I do get from landlords, and it's in rental agreements and it's technically not legal, is that the landlord has the right to do an annual inspection under the lease agreement. Okay, now technically speaking, under Civil Code Section 1954, there is no statutory right under that code section to do an annual inspection. Okay, and generally speaking, a tenant cannot waive any rights or protections provided to them under the civil code, from like Civil Code Section 1940 all the way up to like 1950. There's a whole bunch of them basically. Okay, you generally can't waive your rights as a residential tenant. Okay, they can be more restrictive, and courts will enforce more restrictive terms, but I don't think a general inspection clause would be enforceable. Okay, now there are some code sections, there's some health and safety code sections that allow landlord entry to check for smoke detectors to make sure they're operable, because landlords are responsible for making sure those things are maintained. I just caution landlords that you generally, unless you have consent from your tenant to do like a general inspection, don't try to skirt the law on this. I don't think it's going to end well for you. Okay, it's so there could be provisions in there that are actually illegal. They're not permitted under the civil code, and a tenant can't waive their rights to them. So in this case, a more restrictive term possibly could be enforced against the landlord. I would just caution landlords to not overly restrict your ability to get into a unit, because what's going to happen is, especially if it's something that a landlord needs to address, like a habitability repair and so forth, if there ever is a dispute about entry, all you're creating is more expense and pain for yourself. Okay, you're gonna have to get a guy like me or someone to kind of sort through these things, try to negotiate stuff, that type of deal. Luckily with this landlord and tenant, per the commenter, they get along. But I know a lot of folks that don't get along, and they'll spend tens of thousands of bucks trying to just figure things out. Okay, not worth the risk, or not worth the hassle if you can avoid it. Okay, landlords, if you're having issues getting in access into your home, or you have questions or concerns, or you need, counsel on like how to address a problematic tenant problem, you're in the Northern California area, feel free to reach out. You can hit our profile down below. It'll take you to our website, and you can book a free case review to discuss your tenancy matter. Put your comments, questions down below. I'll answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.